By the time an inquiry had been conducted, more than half the jurors said that that conversation had impacted upon them, and the entire trial was squashed, and an entire month of work basically went down the drain, and we had to start over. So I understand jurors. I have sat through many, the first day of the month when they ask all these persons who are called to serve as jurors. They come bearing letters from employers. They have all sorts of excuses. They do not want to serve at various points in time. There's also the challenge that a number of exemptions already exist in the Jury Act. The pool of persons who are eligible to serve as jurors is already narrowed down by these exemptions. And then you have other persons coming to seek exemptions. So jury trials do, in fact, pose some challenges. But that does not take away from the fact that the right to trial, there's no constitutionally protected right. But a person's right to be tried and to be judged by a jury of his peers is very important. Because you see, what a jury brings to a trial is something that I would say I don't believe a judge alone can bring. And that is the practical, everyday experience of the average man and woman in this country. How the average man or woman would react to a certain situation. How the average man or woman would be expected to respond to questions posed to them by the police in cases where you're dealing with confessions. Those are issues which someone who lives a very cloistered and a life that is sort of, limits their interaction with, I think the UK expression is the man on the Clapham omnibus. I've West Indianized it to the man on the priority bus route. But if you don't interact with the man on the priority bus route every day, the man standing up down at City Gate, the man walking around High Street in San Fernando, can you really judge the average person and their reaction? That we have to balance that requirement for expeditious trials, for more cost-effective trials, for to rid the system of all of the challenges that we may have when juries perhaps have prejudice, and sometimes it is more difficult for the average citizen to disabuse their minds of certain prejudices, like where a person is from, etc., as opposed to a judicial officer. And you are accused and you are brought before the court. You want someone who is just like you, an average person who understands your story, your background, your history, your thought process, to be the ones who will determine whether or not you should be convicted of an offense. How do we balance those things? And that's what we're here to discuss today. One of the things I want to discuss really is the reduction in numbers for the juries, and then we're also dealing with situations where we have no juries at all. And I think that's the more concerning part of this bill. By reducing the numbers for non-capital offenses from 9 to 6 and for capital offenses from 12 to 9, you're limiting the amount of experience that is brought to bear on that process. I assume that the reason for doing so is because it makes it easier to impanel the jury when you have fewer people to find. It would have less cost attached because, of course, jurors are given stipends and so on. And when you have a wider pool, you eliminate the risk, or you mitigate against the risk of all persons sitting on a jury perhaps thinking one particular way. You increase your chances of having diversity and diverse opinions coming together to debate the guilt or innocence of a person. So the reduction in these numbers, I believe, requires some serious consideration, and I don't think it is something to be treated so lightly, simply to say that it will make trials easier for us to have.
So that was Senator Jayanti Lakshmidiyal there speaking after Reginald Amor, Attorney General, I believe, reread the Miscellaneous Provisions trial by Judge Alone Bill 2023 in the Senate on Friday. She was the first person to respond to his presentation. She brought up more concerns. One was with regards to how the parliamentary debate process happened, because certain information was not made available before, but that's beforehand, but that's a separate question. She also had other perspectives with regards to the debate with regards to juryless trials. But your initial thoughts, because I know there's actually some other drama that went on towards the end of this debate, but before that, with regards to this topic, where do you stand, Ketan?
I think it's something that we should explore. I wouldn't immediately shush it out. I don't think jury-free trials are the only way that is going to try and resolve the criminal justice system, because it's not the only factor. But at the same time, it's certainly something that needs more explanation and more examination, and it's something that we should hear from, not only from attorneys at law, but also you'd like to hear from criminologists. I believe a couple of them have already spoken, and even stakeholders, even members of the public. And the reason being is because, just as how she said that how you want to be judged by a jury of your peers because it's somebody who can relate to you. Okay, the individual who is defending you, your lawyer, do hoity-toity lawyers actually, are they in line with what people actually face? Because they're going to courts and they're going to defend them, right? But they may not necessarily understand or recognize it, yet they're still going to court on their behalf because that's their qualification, that's their job. I think the situation for me is the issue with respect to judges. The bigger issue is if judges take bribes, how are you going to actually have a fair trial? That is one of the things that needs great examination. If I were to, utilize the comments made by the Minister of National Security that exactly. Criminals have friends in every single place. Trial is a small place, so even if you have a judge who has friends who are criminals, the same thing could be said for members of the jury. You never aren't entirely sure what the relationship is. They may not be related, but they may know of the individual, and they may simply say, I don't know of the individual. So however you examine it, there's always going to be risks. Mm-hmm. The thing you have to look at the most is whether or not it's going to have greater benefits. And to be honest with you, I'm not entirely out of saying no. We should not have judge-alone trials. At this point in time, I'm more neutral on the case, but I'm not shutting it out completely.
So a couple other things that the Senator brought up, one of which was the fact that she felt she did a lot of special victims, sex offenses, crimes, and she felt that a lot of the victims would come back and they feel a lot more comfortable telling their story to a jury rather than to a single judge who his perspective or her perspective will be very, very unique and aloof to their situation as opposed to telling their story as victims to ordinary people. And there's something about the fact that, yes, it's not just about the jury. She said this. It's not just about the jury judging the accused, innocent or guilty. It's also judging witnesses, the veracity of all of the evidence, of all of the testimonies and the witness statements. So that's what that will impact as well if you just leave it to judge. It's interesting that literally within a couple of weeks, the Minister of National Security says, well, you have judges who have friends in criminal spheres, and then now you're looking to push juryless trials that will be handled by judges alone.
Yes.
One of the biggest things and that the Senator said was there was a part where she vehemently opposes, and it's a part that says that the court so directs in the interest of justice. And her interpretation, so I'm not entirely sure if this is correct, is that somebody could come and request to have a jury. You don't want a juryless trial, but because the court so directs in the interest of justice, the judge might actually say, well, no, in the interest of justice, I think I will just hear it without a jury. But she's concerned about that clause where a judge could basically say, no, we are going to go juryless, based on how the legislation, I believe, is currently written.
Lawyers may not actually agree to this simply because judges go strictly with the law. Right? Lawyers interpret the law and make a case for their client. A judge will actually make a judgment based off of law. And that probably will not work in favor of their clients. Also, the longer a trial goes on, or the more consultation is needed with a lawyer, currently they make more money.
Yeah.
Right?
Yeah.
So think about it from that perspective as well. So you're not going to hear a lawyer actually agreeing to this at all. You're not going to hear about that. But I certainly also think...
the Senator is a lawyer.
Well, yeah, the Senator is a lawyer. And I'm not saying that she came out with blazing guns. She raised, good points. But I think they're not, for me personally, I don't think it's that much of a great argument on the basis of it. If judges were to rule on law, and they could basically judge evidence as well. They could judge witness statements as well. I don't see why not. Another thing, though, is this also going to try and help resolve the fact that even if you have a judge or a jury trial, sometimes documents don't make it to the court, wrong documents make it to the court, police officers don't show up to the court.
Yeah.
So this is what I'm saying. This is not going to solve the issue. There are multiple factors, but I mean, it's possibly one way to try and put a band-aid on it.
Well, put a band-aid. I mean, Independent Senator Evan Welch, apparently he agrees with Senator Lushmedial. He is like, look, the standard is 12. Why are we going below 12? Again, that's for capital offenses. But what was interesting as well, just to wrap this up, on Friday, the debate was more or less suddenly halted, and it seems as though come tomorrow, the government will be going on with the finance supplementation and variation of appropriation bill, and they have not wound up this judge alone debate, and they also, the government, the head of government business, Gopi Skoon said that they did not give a date with regards to when that will happen. They didn't necessarily give an explanation as to why the debate was suddenly halted. Some has proffered, it might have been Senator Lushmedial herself, that perhaps the debate caused the government to want to withdraw and do revisions based on what the debate, opposition debate has said with regards to what the independents has said, the Law Association has said, and the Criminal Bar Association has said. They have all apparently come out with serious concerns about the bill, I believe, as written. That is not to say that they are against juryless trials, probably, so to speak, or reducing the number of jurors, but I think a lot of it comes down to that boogeyman with implementation all over again.